Snowstorm on the TV glow, red scarf, crescent bow, Santa Claus with a candy cane pen, Sailor Mo hits pause again. Hey! Timeline tangle like tinsel on the floor. Where's the motive? I still want more. Santa flipping through those files so fast. Who checked the bottles? Who asked the past? Mo draw stars on a legal pad. Did they chase every clue she had? Screenshots, text logs, late night calls. Did they map every crack in those walls? Santa Claus, there, Momo, shouting at the screen. We need to know. Did they chase every shadow, every sign, or skip frames in the storyline? Justice meter starting to glow. Hearts on fire in the living room row. Anime eyes locked on the show. Santa Claus and Sailor Mo. Search the background, check the train. Mo says sketching out a chain. Phone ping, slips, what's the trail? Who wrote the tale if the facts are frail? Santa slam Coco leans in close. Where are the notes from the first diagnosis? Did they test what they couldn't see, or just trust what was easy to believe? Santa Claus ain't low, shouting at the screen. We need to know. They chase every shadow, every sign, or skip frames in the storyline. Truth or plot, high or low. They're counting every cut, each flow. Anime eyes locked on the show. Santa Claus and Sailor Mo. Objection in my heart, Mo cries. Cutscene gaps and alibis. Santa's list of questions grows. Who watched the watchers? Who really knows? Santa Claus and Mo, shouting at the screen. We need to know. Did they chase every shadow, every sign, or fade out on the steepest climb? If truth is heavy, let it show. Let the whole strange story glow. Anime hearts won't let it go. Oh, Santa Claus and Sailor Mo.
Hello, folks! Yay!
Yay.
Day 13. Look at me! Look at me! I'm here.
I know. I felt so bad because
got-
as soon as you had been hyping the, walk the dog letter
Mm.
like the whole time. And I was like, okay, cool. We are going to. And then you had like a long, long day and I felt bad because it was.
Yeah. Now today, I chose to sleep an extra hour this morning, and I chose to some of my coworkers, do not steal my. I bought myself a small bag of candy, and apparently Mr. Jingles likes the color yellow. So he's
Doggone it.
eyeing this bag, and he's there on a box just.
Yeah, no, Dingus is eyeballing me from my side of the bed, stretched out to cover like the entirety of my bed, just like, yep, this is mine now.
Oh yeah, yeah. So I missed how they presented the Walk the Dog letter. Now I've read it a few times. I also missed, of course, the cross-examination. I heard bits and pieces from Ian Ronco's stream this morning, my time. And I heard a lot of, I don't recall. A lot of them.
I was never more frustrated than I was on a ranty mode, but never in my life. I don't care that it's your first job. You think that you wouldn't want to look like a moron your first time out, so you would have written notes. You would have had your reports printed out. The state had to be aware of this. He has a very casual, lackadaisical attitude. They had to be aware that this is the type of person he is. And then they should have had a binder ready for this ridiculous man.
Yeah. Or they want him oblivious because his reports are like him.
This very much seems like a Uvalde thing where no one was really prepared for a murder trial. So they had 100 different people on it. I hope that they've figured out, something new, because if another crime like this happens, I hope that they're more prepared.
Yeah, you can always hope. You can always hope. And the final thing I want to see is because defense diaries, according to them, something happened at the very end of yesterday. And they are complaining because more or less they were the only one noticing. So I'm going to keep a lookout for that thing as well. So today we're going to start with what I
will
missed
say,
yesterday.
I was kind of thrown off with the whole presentation for the state has been just flipping it on and letting everyone read. So I wonder if they had to get special, permission from the court, because it seems like the court has basically been show them up there. You're not to read them to anyone.
Yeah, I'm. This is some weird Utah rule that you can't read them out loud. And I mean, it is the jury who decides what tone it is, what's the meaning, what's the emphasis, and if you choose somebody else than the person who wrote it, then they will add their own thing, like Prosecutor Love did in the YSL trial when she read texts, and she put her own emphasis on things. And let's just say she will never have a rap career.
I will say, as someone who tried to avoid the walk the dog letter until, it was incredibly damning.
Yeah.
I think that, again, had they picked any other lead investigator who was just slightly prepared, that would have been a complete mic drop moment. But then we got his cross.
Yeah, so this will be interesting because I know the walk the dog letter, but I don't know how it's presented, and don't know this guy, even though people claim he's my long lost son. So let's go through it.
Submitted and published.
Detective O'Driscoll, can you please, starting at the top where it says page 1, read this letter aloud?
Page 1, walk the dog, but take vague notes so you remember. Here is what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week. Upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me because I would get mad, because I always said he just gets high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck, so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag and it would cause a huge fight. She was pissed he would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. Kouri has never done any type of pills, didn't like them. Rarely would she consume THC, only if Eric begged her because it was a special occasion. Reword this however he needs to make the point, just include it all. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. It can be short and to the point, but has to be done. Upon information and belief, LOL. They never found pain pills or fentanyl in my house because he hid it in allergy bottle in work truck, and Cody emptied out work truck within a week, so they were never found. When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to SL and meet him after work without Bree. Tell Ronnie, don't overanalyze it. It was a quick 2-minute conversation, LOL. Tell him I need him to do this. Bring me home and then we will get those damn bitches. Also, please text Lotto or call. Tell him do not text me anything about us doing things together ever. Like church, skiing, trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through. Have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon. Take vague notes of all this so you remember before you walk the dog.
Yeah. This is the most stupid thing I have seen a defendant do and she tried to hide it as a letter to her lawyer. And, well, her lawyer fucked off, of course, because the implications here is if she doesn't, yeah.
Well, basically, if the lawyer goes along with this, she's knowingly going along with a false testimony that's against her ethics.
Ow.
And I think what people who don't actually look at law and don't, deal with it, they assume lawyers, especially a defense attorney, can break all the rules. Like whatever I make up, you just say it and then I get off. They don't understand that most lawyers do have a rule of ethics. They very much value their bar license. They do not want to lose access to the job for which they went to school for years and years. So they do have,
I mean, once the student loans, if you take an American American lawyers, once those are paid off, you want to start paying off your next yacht and stuff. But this, I don't know how I would spin this as a defense attorney. I know what they tried to spin it as. Oh no, this was just a draft for her next book. It's like the panic to get around.
Logically, it doesn't make sense. So she starts the whole, hey, have Ronnie remember this.
Yeah.
She starts it with Eric never told Kouri. So you get halfway down that paragraph and then she said, oh, eventually Eric told Kouri to have Carmen get fentanyl. So don't you think that Kouri sitting in jail, should this have actually happened, would flip on her husband at that point and say, hey, look, he did have a fentanyl problem. I hooked him up with Carmen. Yeah, I did help, but I'd like to get out of jail, please.
Yeah. There are so many ways for her, because what she said at when they talked to her that night, she said she didn't know. No, he doesn't have a drug problem. That could be easily explained away. I just wanted to protect him.
Yeah,
he was high as a kite all the time. But this here, it's astonishingly, it is beyond stupid.
I mean, I almost wonder if she was trying to push a mistrial even here. I mean,
No,
I
she is so used to getting away with everything. I mean, she got the rich husband, she got a few kids, they had a good life, she had her side piece, she was convinced she was a really good realtor and house flipper. She just needed that one extra thing. Oh, next house. That will make every debt go away. Next thing, next thing.
yeah, and it's not even a coherent telling of the story based on the facts. Again,
Mhm.
if this were true, Kouri would eventually say, "Look, you're gonna find fentanyl here and here. I'm pretty sure he kept it here." I mean, she would have eventually said, "Hey, okay, I'll tell you where it was. It was in his truck. You know, ask Cody if he threw it out. It was in an allergy bottle."
Mm.
And she could have said that through her lawyer. I mean, it's not like she needs to, give up her Fifth Amendment right.
Mm.
But had any of this been true,
No. It is so insanely stupid. Instead of I'm not giving hints on how to get away with things. Simple. The truth is always simple because you don't have to try to remember it. Because it's the truth. Short, consistent, don't add anything, don't take anything away. If you're going to talk, just boom, the truth. Or shut the fuck up. Don't talk about your crimes on jail calls. Don't write letters posting it through your lawyer to people you want to lie for you. It's insane. And this letter alone, they could have skipped almost everything.
well, and that's what I wonder once you get to the end of the cross. I think that the letter is very damning,
Yeah.
but I don't know how much of an impact it had after that cross.
Yeah. So let's get ahead.
Detective, does Sky in that letter refer to Sky Lazaro, Kouri Richins' former defense counsel?
Yes.
No further questions, Your Honor.
All right.
Please.
Thank you, Eric. Let's jump right back into that letter since we're on it, while it's fresh on our memory. It's Exhibit 286 for the record.
You want me to put it back up?
Yes, please, Your Honor.
There you go.
Thank you so much. All right, so this letter that you just read aloud, do you know the date that it was written?
I believe it was September either 12th or 13th.
Okay. And in this letter, the very beginning letter tells, I guess if it's her mother that she's addressing it to, if that's what you say, that to remind Ronnie to tell Sky this story, correct?
Well, what part are you referencing?
The story about what Eric told him about getting fentanyl from Mexico.
There is a part that says tell Sky at the meeting next week.
Okay. So it looks like there's about to be a meeting with her lawyer, Sky, right?
I have no idea if that happened or if that was about to happen.
Okay, well, that's what it says.
It says at the meeting next week.
All right. So there's a meeting coming up with the lawyer, and Kouri is relaying something that Ronnie had known from the past, and something that occurred between him and Eric in the past, right? When they were watching a football game.
You pause for a moment. Go ahead, Mr.
Objection, Your Honor. Foundation.
Sustained.
Okay, let's blow it up. We're going to get very particular. All right. A year prior to Eric's death, Ronnie was over watching football one Sunday, and then she tells a story about something that Eric allegedly told Ronnie, right? And just by the way, if you could go up just a little bit above that.
Wait for the answer.
Wait, before let me rephrase. Katie, if you could go back up to he will need to tell Sky at the meeting next week, just start right there and then highlight. And then thank you. I'll rephrase.
You're withdrawing that question?
Yes, sir, I am.
Understood.
So he's going to need to tell Sky next week about a year prior to his death, something Eric told Ronnie, allegedly, right? About his trips to Mexico.
Your Honor, there's no question there.
It ends in a question mark.
Thank you, Your Honor. Right?
It includes the word allegedly.
Yes. Right?
Any other objection?
Your Honor, perhaps you could just re-ask it again.
Sure. One more time, Ms. Nestor.
In the letter, because you said you weren't sure, so we're looking right at the letter. In the letter, she says at a meeting with Sky next week, and she talks about Ronnie telling a story about a year prior to Eric's death, Ronnie being over watching football one Sunday and talking to him about his trips to Mexico, right?
That's what the document says.
Okay. As the chief investigator of this case, did you ever go to Ronnie and say, hey, did this happen?
I believe investigators reached out to Ronnie. I don't think it was me, but I believe one of the other investigators reached out to Ronnie for interview and were not able to talk to him.
So the answer is you were never able to confirm or deny with Ronnie whether this actually happened.
I was not.
Okay, let's go to the next page. Then she tells a story about Eric putting drugs in her bag at the airlines right before they board. You see that? Can you highlight it, please, Katie? Now, that story has been verified by Allie Staking, her friend that testified before this jury, correct?
Objection, Your Honor, foundation.
Have you been sitting in this?
The objection's overruled.
Thank you, Your Honor. Is that right?
Could you rephrase the question?
That story about Eric putting drugs in Kouri's bag when they would travel and causing a fight was verified in this courtroom by Allie Staking under oath. Is that correct?
I listened to Ms. Staking's testimony. She told of one incident when that happened.
Okay.
This says Eric would, as if it happened multiple times, so I don't know. I just know what I heard Ms. Staking testify to.
Did you ever ask any of Kouri's friends or family if they knew of situations where it had happened before?
Where what had happened before?
Where Eric had put drugs in Kouri's luggage when they traveled?
I don't recall asking that specific question, but I think I heard about it coming up. I don't remember who the conversation was with, but I think I had heard something to this effect before.
Was it involving a trip to Mexico?
Not specifically, no.
Okay. Do you remember where the trip was involved?
I don't. Sorry.
So at least someone in your investigation did at least suggest that they knew of another situation besides Hawaii where Eric did this.
No, I don't know if it was a separate one or if they were referencing the same one. I don't know for sure.
All right. All right. If we could go to the bottom of highlight the bottom half for me. All right. There's references in here that Ronnie will have messages on his phone to prove Eric confided in him about getting high, right?
That's what this text says.
As the chief investigator of this case, did you ever go check Ronnie's phone to see if those existed to verify this?
I was made aware of this letter after May 8th.
Of 2023.
Of 2023.
Okay.
Like I said, I believe investigators reached out to Ronnie to talk to him in general about the case, and he denied letting us talk to him. So, no, I was never able to confirm this with his cell phone.
So we sure have sat in this courtroom and listened to
I have a question. So let's say they were competent investigators and they wanted to corroborate that Eric, contacted Ronnie about any of these things. What are the police's, options if they have a witness that doesn't want to talk to them?
Oh, well, the first option should be, is this in Eric's phone? And according to the state's opening statement, they found nothing of any drug
Drug-seeking behavior or...
Yeah, whatever they called it. But that also... Did Eric have more than one phone? What about his work phone? His private phone? Did he have a third phone? Did they look for a third phone? And we know they didn't, because none of these idiots checked his work truck.
Yeah, I'm really torn with this case, because do I believe down at the brass tacks that she did it? Yeah. Do I believe the state has proven it? No. Do I think she's going to be found guilty? Yes. And I don't know where I sit with that, because, with Edric, we definitely believe he didn't do it. But I also want to hold the same standard because I don't think the state has proven this.
Mm.
But she's a really dumpster fire human.
Mm. Now, regardless of this letter, I mean, not looking through his work truck, if they are actively trying to find out what happened, did she slip him? Did he take it by accident, or was it self-ending? Why exclude the work truck? So no, there's so much. So I said this before. Without Kouri Richins being Kouri Richins, this would be a really weak case. But since Kouri Richins is Kouri Richins, she's going to put herself in prison for the rest of her life.
Basically, had she done nothing more, I think they have her. I think they have her on the financial stuff.
Oh yeah.
But as far as this, had she kept her mouth shut and just not, wild out just a little bit, I don't think they could have ever proven anything.
It would have been a much, much harder case to prove. But reality is, Kouri Richins is Kouri Richins. And she implicates herself a fucking lot.
Yeah.
So I'm on the fence. Do I believe it? She did it? Yeah. Do I believe she did it knowingly? That's another issue. I would have been much more comfortable with her, hey, have some of my stash. and she didn't know it. What a few of those were fentanyl laced because Carmen didn't care. She just sold.
Yeah, and I could even go with I bought these thinking they were Oxycontins because my husband, was in a lot of pain, and I had no idea that. Look, I'm not a drug dealer. I'm not a drug person. I got like my friend who was a drugologist, and she told me these were good. That makes sense. But I am going to hightail it for a little bit. I'm going to get food, so I will be back. And
you go get food.
Yes,
and I'll see you later. All right, folks. Thank you, Mo, for being here. Even if it was just for just under half an hour. Folks, if you are a regular here, you know I'm always pro-defense until the state prove me otherwise. And first of all, the state should thank their lucky stars that private investigator got himself involved. Because without him, they would never have gone back 10 times. They would not have found everything they found. So yeah, this seems to be a case of barely competent investigators striking luck with Kouri Richins being a C word, and Kouri Richins sued the family civilly, which got a competent investigator involved. They should thank their lucky stars, because without those, they wouldn't have much. But let's listen. Let's keep listening. We will catch up. I see that today's court already started, but we will catch up because there is one other thing I want to get to.
A lot of testimony about search warrants to seize phones. You know how to do that, right?
I do know how to do that.
Didn't issue a search warrant to get Ronnie's phone to see if that happens to be true.
No, but like I said, this information came to me well after May 8th, 2023.
Okay, sir, that's 3 years ago, right?
Yep.
And isn't it true you issued a search warrant as recently as 2 months ago to search the house for, I think, the 10th or 11th time, didn't you?
Yes.
Okay. All right, and then can we go to the very last little bit about they never found pain pills or fentanyl in my house? At the bottom. Yes, please. Thank you.
I can see that.
You can see it? Great. Okay. So again, this refers to the previous page where Eric allegedly told Ronnie that he kept his drugs in an allergy bottle in his work truck so that Kouri wouldn't find it, right?
Objection, Foundation. That's not what the previous page says.
We just go back to the previous page.
Sure.
And use the
Absolutely. Katie, can you go back to the first page and find the section in there about where he kept his drugs? Let's see. Yep. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them. Isn't that what that says?
The whole sentence says Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them.
And by the way, this was seized September 14th of 2023, correct?
I believe so, yes.
And at that point, had you revealed to Kouri that you had found an empty hydrocodone bottle in Eric's nightstand the day of his death? Had you ever revealed that to her or her lawyer at this point?
I personally didn't find the bottle.
Okay.
It was located on the night of Eric's death and was transported with his body to the ME's office.
There's no way for Kouri to know that when she wrote this, right?
Objection, Your Honor. Speculation.
sustained.
Okay, that's fair. All right, go back to what we were just talking about, to the bottom of the second page. All right. The never found pain pills or fentanyl in my house because Eric hid it in an allergy bottle in the work truck, right? So that connects to what we just saw on the first page of what he allegedly told Ronnie, right?
What is your question? Yes, I can see that this document says that.
And the next sentence says, and Cody emptied I'm sorry, it's cut off on my screen, but not that one. I'm going to share a screen with the jury. And Cody emptied out work truck within a week. We've heard that verified by Cody in this courtroom that he said to the jury under oath, correct? While you were sitting in here.
Objection, Foundation. I don't think that's what he said.
Sustained. You got to rephrase.
Did Cody come pick up the work truck within a few days of Eric's death?
I'm not personally aware.
Did you sit in this courtroom here and testify to that?
I believe so.
Okay.
Yes, I sat in the courtroom. Yes, I heard his testimony. I don't remember exactly what he said, but
And just in case the jury has been so
This is the lead detective who apparently didn't know where the items went directly within days of Eric's death.
focused on that witness box that they don't notice what's happening back here. You've actually been in this courtroom every single day, every single minute, listening to every single person testify, right?
nearly, yeah.
Almost.
Almost.
Maybe a bathroom break here and there, which you're entitled. Okay. All right, let's take that down. Now, I want to go back to, oh, by the way, just last little thing on the walk the dog letter, and then I swear I'll quit beating a dead horse. But the walk the dog letter, to your knowledge, was the walk the dog letter.
You're in a murder trial, lady. Do not reference beating a dead horse. Yes, we know the expression. It sounds awful.
Ever delivered to Kouri's mom, to her brother, to the lawyer, to anybody?
I don't believe so, not to my knowledge.
Okay, thank you. All right. Now let's back up just a little bit to your entry into this case. Oh, Your Honor, I left my notes. May I please return to the table? Too excited and ran up here too fast and left all my questions for you on the back. So, okay. I want to talk to you about the time. So you basically, before you even entered this case as the new head of the investigation.
Lead investigator.
Lead investigator. Thank you so much. I want to use your terminology. Before that, you did what's called a trash cover at Carmen's house, right?
We call it a trash rip.
A trash what?
Rip.
Rip. Okay, I've never heard that. So you did a trash rip at Carmen's house, correct?
You referenced a time frame. I don't remember what you said. Could you rephrase it?
Would it refresh your memory that around February 21st of 2023, you searched Carmen's trash?
It was probably around that time, yeah.
Before you were technically the lead investigator of this case.
That's possible, yeah.
And you said you found some foil, right?
Yes.
And that's usually an indication that someone's been maybe freebasing, heating it up in foil, and then smoking it, typically.
I don't know the term freebasing, but
I'm from the 80s. I'm old, so you probably don't know that term. But
from my experience, people will put a substance, any substance that they want to smoke, on top of tinfoil. They'll heat it from underneath with a lighter or torch, and then they'll smoke the fumes that come off of the substance.
okay. And did you test the substances that you recovered from her trash that day?
I believe we submitted some of those pieces of paraphernalia to be tested, but I don't remember if we ever got results for them. If they were only Nik tested, I don't remember. I have to check records.
Would it refresh your memory to say that only meth and heroin were recovered and no fentanyl?
Like I said, I can't remember without checking my records.
You certainly can't tell the jury under oath that they got fentanyl out of her trash that day, right?
No, I don't remember us finding anything that was confirmed as fentanyl.
Okay. And then at the end of March, I believe, someone started tracking Carmen's car. Is that right?
Correct.
Was that you all or was that Mr. Gabler?
Who is you all?
The law enforcement, sorry.
We did apply for a GPS tracker warrant for Carmen's vehicle, yes.
All right. And then you get to be assigned a lead investigator around April the 11th.
I think it was in March sometime. I would have to check my notes again, but I believe it was about mid-March, early to mid-March.
Okay. And the first real step that you took as lead investigator, would it be fair to say that was when you applied for a warrant for Kouri and Eric's cell phones?
Oh, it's been just as long for me as everybody else. So I remember.
You're the lead detective. Study your fucking notes.
Remember that I applied for a warrant for, well, I'm sorry, I don't remember. One of the first things I remember doing is applying for a search warrant for medical records for Kouri.
For Kouri?
I believe so, yeah.
Okay. All right. And did you also apply for medical records for Eric?
I think those had already been requested or seized subject to a warrant.
By Detective Woody. Actually, I think she did testify to that. I think that's right.
I believe so. One of the investigators previous to my getting into the case.
And then you decided to knock on Kouri's door and interview her, right?
At one point I did, yeah.
And when you showed up to interview...
Objection, Your Honor. Be on the scope.
Sustained.
Can I have the court's indulgence for just a moment? I need to go chat with my co-counsel for just 1 second.
No problem.
All right, so we are going to leave that topic alone and we're going to move forward, okay?
Okay.
Also, the other things that you did in the mid to end of April of 2023, shortly after you were assigned to the case, you also looked at extracted Kouri's cell phone, did you not?
Yes, I'd have to verify the date, but yes.
Okay. And when you extracted the phone, were you able to start looking at her texts and looking at everything in her phone?
Yes. At this time, we had just acquired our own forensic equipment. So previously we relied on the RCFL for our digital forensic evidence extractions and so forth. We had just started getting our own forensic equipment. And so I downloaded Kouri's phone, and I don't remember the format of the software to analyze it, but I do remember seeing the text messages and the gaps in the text messages.
Was that the first time you'd ever extracted a phone on the new equipment?
I don't remember it was the very first, but it was one of the first times, yes.
And was there anybody who assisted you in doing that extraction?
Yes, Miss Gibson did.
Right. And are you or Ms. Gibson certified on Celebrite or the extraction gray key, whatever you use to extract it?
Miss Gibson is. I'm not.
All right. And then after you extracted Kouri's cell phone, you interviewed Chelsea Barney, did you not?
I did.
And Chelsea's testified here. Chelsea was Ms. Richins' dear friend from junior high, right?
That's what I understood, yes.
And when Chelsea came in to be interviewed, didn't you tell her that you had evidence that she and Kouri had spoken the night of Eric's death?
Chelsea did not come in anywhere when I interviewed her. I interviewed her in her home in Heber.
Oh, were you present when she did the interview at the sheriff's department?
No, I was not.
All right. So when you interviewed her at her home in Heber, did you tell Chelsea that you had evidence that she and Kouri had spoken the night of Eric's death?
Yeah, just a foundation as to what time frame are we talking about?
Can you?
A little foundation
Sure, I'm
work.
glad to. Can you tell us when you interviewed Chelsea in Heber?
I can't give you an exact date. My best guess is it was probably April sometime of 2023.
Before Kouri's arrest date.
Correct.
And when you interviewed Chelsea in April of 2023, did you tell her, did you represent to her that you had evidence that she and Kouri had spoken the night of Eric's death?
I don't think it was phrased that way. So we had some interest in the timeline of their communication between Chelsea and Kouri the night of Eric's death. Because when we looked at what was available on the phone, it appeared that Chelsea and Kouri texted every single day. Like they were always talking with each other. And then there was a gap, I believe, between March 2nd and March 4th. So that stuck out to me as unusual. And I did bring that up with Chelsea and just asked her if she knew of any reason that there would be that gap. And then she was actually able to produce some documents from her cell carrier that we went over together, and it looked like that matched up.
So you originally suspected that maybe she had deleted a conversation with Kouri?
That's what it looked like initially, is that there was an unusual gap in communication between these two best friends that I understood them to be.
Okay. And it turned out that was incorrect, right?
From what I'm remembering, yes. So there's some confusion because there were just personal direct text messages between just Kouri and Chelsea. And then there was a group chat of all their friends.
Right.
And it was hard to distinguish in the beginning which occurred when. And I think that's where some of the confusion came from.
But ultimately, you were able to agree with Chelsea that she did not speak with Kouri the night of Eric's death and did not delete any messages with Kouri, correct?
I couldn't find anything that suggested otherwise.
Right. And then was Chelsea unhappy with the way that you all handled her interview?
I don't know.
To your knowledge, were you aware that she filed a complaint that she had been misled about her phone when she was being interviewed by your office?
I was a
No, just objection foundation. I think timing's important here. I think counsel's confused about two different interviews, so I think we need foundation on timing.
Would you just be more specific about the complaint or what it was about with some month and year?
Yes, sure.
signposts?
Shortly after Chelsea was interviewed, the time with you and the follow-up time, did she file a complaint against your
Oh,
office?
that's the problem. Can you break it down one at a time? They're two different events.
Just a moment.
Why? It's following two events. For me, it's clear. Okay, so you interviewed her twice, and then she filed a complaint against you, correct? Or is it? I think that's quite a simple question. Now, she does space out all the time, so maybe her leeway is gone by now. So the judge reels her in automatically.
Okay, I understand now, Your Honor. I'm going to get specific about timing.
Okay.
I think that'll solve the problem. Prior to your interview of Chelsea, was Chelsea asked to come in by Detective Woody? When you reviewed the file, were you aware that there had been a previous interview with Chelsea?
I don't know if it was when I reviewed the file, but I was aware that Chelsea had come in for an interview, and that was prior to when I talked to her.
You're right. And after that interview with Detective Woody, did Chelsea file a complaint about being misled when she was brought in?
Objection, Your Honor, relevance.
Help me out. I'm not sure where we're headed.
Your Honor, do you think it's relevant?
Why don't you approach for a moment?
Okay.
Yeah. At the end of yesterday, we were up to 85 sidebars. That's quite a high number. We will probably reach 100 before the end of trial.
Interviewed and in addition to you interviewing Chelsea at her home in Heber sometime in mid-April, you also interviewed a close friend of Eric named Jake, right?
Yes.
All right.
Jake Sorensen.
And then you at the end of April is when Mr. Bloodworth said on April 26th, when you got the warrant and executed the warrant on Carmen Lauber's house, right?
We executed a warrant on Carmen Lauber's residence on April 26, 2023.
Right. So between April 11th or end of March, when you first joined the case, and April 26th of 23, you possibly got a warrant for cell phones. You extracted Kouri's phone, interviewed Chelsea and Jake. And then that's when the seizure happened at Carmen's house, right?
I'm not sure what you're referencing about the April 11th date.
That's the date on your report when you were assigned to the case. So that's the date I've been using. But if you remember it earlier.
That's the date that I wrote the report.
No. I mean, it doesn't matter to me. It's not. If you remember it was the end of March, we'll go with that. That's fine. I'll use the end of March.
But
Okay. And then you search Carmen's house. And then the next day is when we saw the interview that you had with Carmen at the jail, right?
yes, so Carmen's home was searched on April 26th. That same day, she was arrested for driving on suspended license. And then the next day was the first time that we spoke with her at the Wasatch County Jail.
So first, the search of her house. Was any fentanyl located in her house at all?
No.
No. Then when you go to interview her, do you know what time of the night or the day she was pulled over for driving with a suspended license?
It was in the morning.
And what time of day did you see her on the 27th?
I don't remember.
Okay.
I would have to look at the timestamp on the video of the interview.
And I watched the interview, but I never saw anyone ask her if she was under the influence while you were interviewing her. Did anyone ever ask her that question?
I don't remember. I don't think so, but I don't remember.
And is it fair to say in that first interview, before any promises have been made about leniency or anything, Carmen denied ever being asked for fentanyl by Kouri Richins?
Yeah, I testified earlier that drug dealers, in my experience, when you interview them, will initially...
Well, let me stop you. I'm asking about Carmen, not other drug dealers. I'm asking about Carmen Lauber. Did she deny ever being...
Do that more often. When he starts spacing out, don't be scared to interrupt him. Do that more often.
asked by Kouri Richins for fentanyl?
Yeah, as most other drug dealers also do when I interview them.
And did she share with you a personal tragedy that her daughter had OD'd on fentanyl?
Yes.
And did she tell you that because of that, she didn't mess with fentanyl?
Objection, Your Honor. Hearsay.
I think she's asking about statements from the prior interview. Let me ask a more specific question. Do you mind approaching for a moment?
These are things that has been testified to, so it's already in.
Because of what happened to her daughter tragically, that she did not mess with fentanyl. She didn't deal with it.
I believe those were her words, yes.
Right. And as a matter of fact, the first people that ever injected the word fentanyl into any conversation with Carmen Lauber were you and the other investigating officers, correct? It came out of y'all's mouth first, not hers.
Objection, Your Honor. Argument.
Overruled. If you understand what she's referring to by y'all, go ahead.
I'm sorry.
I did it
I'm still
again.
focused on the previous question because I thought there was going to be a follow-up question about my impression.
No. So the first people that mentioned fentanyl in the interview were law enforcement, not Ms. Lauber, correct?
Yeah, I believe so. Because I think we told her in that first interview that while investigating Eric Richins, we told them that we were investigating Eric Richins' death and that he had died of a fentanyl overdose.
All right. And then you went back and interviewed her again and again and again, right? 5
more distinct separate interviews.
And I believe that I wrote this in quotes because I try to be precise. I believe that when we were listening to the recording, and the jury will, I trust the jury's memories on this, but the phrase, "you're the biggest piece," right? That was said.
Yep.
And that meant you're the biggest piece of this puzzle, right?
In context, I'm trying to remember what was said before that. I think there was a Miss Lauber made a reference to, can we just like put all the pieces together in front of us so we can see how it happened?
Actually, it wasn't can we, it was can you put the pieces together for me, correct?
Yeah, something like that.
Yeah. And then go ahead, I didn't mean to interrupt you.
Yeah, and so in context, we said, you're the biggest piece of that set of information that we're trying to figure out.
And you also, and I wrote this in quotes, and hopefully the jury will recall this the way I do, you hold all the cards.
Yeah, as in she had all the information that we didn't know. And
we saw her struggling and telling you repeatedly that she could not recall dates. She could not remember certain things. Is that right?
She told us several times that she had difficulty remembering, and that
I'm so sorry.
the more that we brought to her and showed her things that were corroborated, the more she remembered and the better recollection she had.
And then within less than a few days of when she finally gave you what you needed, that there was fentanyl involved in her transactions, within a few days is when you issued the warrant to arrest Kouri, right?
We interviewed Carmen between April 27th and May 13th. The warrant for Kouri's arrest was issued by 3rd District Court on May 8th.
But when was it requested? May 3rd? Does that refresh your
I
memory?
don't request arrest warrants.
You signed, you're right, that's done by the county attorney's office, correct?
They filed charges in the case and requested an arrest warrant. We were made aware of it on May 8th.
Within days of Carmen Lauber agreeing with you that fentanyl was involved.
May 8th falls between April 27th and May 13th, yes.
Okay. I wanted to
Yeah, I agree with Gigi here. The attorney keeps gunning for Matlock moments. Ta-da! La-da-da-da! And instead of ask short, pointed questions that doesn't leave opening for debate. Because this is, she only has one gear. This attorney, and she can't adjust to it. We saw it with the private investigator. She cannot, for the life of her, switch gears. That guy was about to bash the cops, the investigation, and she interrupted him because she wanted to get to a moment against him, instead of listening to what he actually said. Same here. Listen to what the guy actually says and work from that, because your tactics is shit.
talk about your investigation into. Oh, by the way, let me back up. Since you have become the lead investigator in this case, have you ever located the hydrocodone bottle that was found on the nightstand next to Eric?
Can you define located? I know where it's been at certain points throughout the investigation.
Okay.
But we don't currently have it in our possession right now.
That's all I need. I want to talk about the Valentine's Day investigation. All right.
Okay.
Katie, can you bring up, just for the witness only, Your Honor, Exhibit 3-13D as in Delta? Do you recognize this exhibit?
Yes. It states Exhibit 3-13D.
And is it fair to say that this exhibit is a visual clip of the locations where Eric was on February the 14th of 2022 based on geolocation in his phone?
Objection, Your Honor. Foundation.
I don't know whether this witness would have the basis to know that, so sustained for now, if you can lay some
I
foundation.
understand what you're asking. As you've been preparing for this case, have you been reviewing the demonstrative exhibits that the state prepared to get ready for trial?
Not all of them, and not this one. I've just seen it in court.
Okay. Did you, as the head investigator of this case, investigate Eric's whereabouts on the days of February 14th, 2022?
Yes, in the sense that Mr. Kouri, the digital forensics expert that the county hired, helped us in the analysis of the phones, and he at some point told us the data that was in the phone regarding Eric's location on the 14th.
All right. So without revealing anything that Mr. Kouri said, what did you learn about Eric's locations that informed how you acted in the future in your investigation?
Well, objection, Foundation. I don't know how he would know that without hearsay.
Well, it's possible that he heard it prior to being in court, and to the extent that is to inform what he did next, we can accept it not for the truth of the matter. Shall we proceed in that way?
Yes, Your Honor.
Let's see what the response is.
Go ahead.
Just so I'm clear, you're asking if I'm aware of Eric Richins' location on February 14th,
Yes.
just based on
The whole
digital
investigation.
evidence?
Yep, and the whole investigation, whatever you did.
Your question was at least tied in some way to Mr. Kotradimos.
Okay, we'll start with that. So based on your working with Mr. Kostradimos, looking at the digital evidence that you went through in this case, do you have a knowledge of Eric's locations on February 14th of 2022?
Maybe pause for a minute. We
Yes.
can just approach for a minute.
Short, poignant questions. That way you avoid all of this
Did
bullshit.
you receive information from Mr. Kostradimos about Eric's locations on February 14th, 2022 that informed your investigation in any way?
I believe so. The truth is, I don't remember 100% for sure if and when I knew about location data from Eric's device throughout the investigation. I would have to go back and review reports, especially Mr. Kotradimos' reports.
Can we, Your Honor,
I just don't remember.
can we see if this document refreshes your memory as to that?
This one or different?
Yes. Can we go through the pages very slowly and give him a minute to see if it refreshes his recollection?
Yeah, objection foundations. I think we're at the same spot we started with a few minutes ago.
Well, we're showing different pages. He testified that he'd never seen the first one prior to being in court. It's unclear whether that's true for the remaining pages that the witness is being shown right now. I imagine we're about to find out.
Thank you, Your Honor. Do you need us to do it again, or did you see them all?
Yes,
Does that refresh your recollection about Mr. Richins' locations on February 14th, or what you knew about them?
It doesn't. This demonstrative Mr. Kotradimos created, and the first time I saw any of these slides was in the court. And like I said, he may have shared that information during our investigation. I just don't remember.
Okay. So Ms. Richins is here today on charges that she attempted to kill her husband on February 14th of 2022. Is that right? One of the charges.
I believe so, yes.
And you're the head investigator of this case.
Yes.
Did you take any steps to confirm or deny Mr. Richins' movements on the day of February 14th of 2022 when he was allegedly a murder was attempted on his life?
Our team did. We hired an expert in digital forensics.
So what do you know about his locations on that day?
That's what I'm saying. What I know and what I remember are probably two different things. What I knew at some point throughout the investigation is that Mr. Kotradimos probably found whatever location data was available on his phone and shared that with investigators. I just don't remember the contents of what those said.
So as you sit here right now under oath in a homicide trial, you cannot tell this jury what Mr. Richins did on the day he was allegedly attempted to be murdered. You can't tell him. That's
Foundation. Now, the question is, you can't say what Mr. Richins did. There's no foundation for that.
Your Honor, that's not the question I asked.
General, I'm sorry, counsel, just ask a more precise question. If it needs to be 3 more precise questions, that's fine.
Thank you, I will.
The foundation objection is sustained.
You cannot say under oath what your investigation showed about where Mr. Richins was on the day that someone apparently attempted to murder him.
I could after a 2-minute conversation with the digital forensics expert that we hired because I just don't retain that information well.
So you don't know.
I don't remember.
You don't know right now, and we're in trial right now. Do you know right now?
Objection, Your Honor. Ask it and answer.
I'll withdraw.
That one was a little argumentative, sustained.
I'll withdraw. Speaking of that, were you ever able to confirm or track Mr. Richins and place him? Did you ever check and see if he ever went to the house in Midway on his geolocation? Did you ever ask anyone to do that?
Objection, Foundation. When?
I can ask him if he asked anyone to do it.
Well, that's a different question. So the question you just asked was very broad as to time frame. Foundation objection is sustained, but please ask a more precise question.
Did you ever ask an expert, hey, can you see if Eric Richins ever went to the Midway house where Carmen allegedly left drugs in a fire pit?
So I was the lead investigator on the case. I was not the only one making decisions.
Do you even know what lead investigator is? That means regardless of who does the things, everything is collected to you. So you have the broader knowledge. It's not just a title. Well, it seems to be just a title in this local law enforcement office.
I am aware that someone in our investigative team directed Mr. Kotradimos to look into Eric's location from his device. Yes.
Are you able to tell this jury if Eric Richins was anywhere near the Midway house around the time that Ms. Lauber claims she left drugs there?
That's a broad date range. So I don't know. I don't have that data in front of me.
Okay. All right. Is it true that through all your interviews with Carmen and your attempts to corroborate what she was telling you, at least one of the times that Carmen allegedly purchased drugs from Mr. Crozier and brought them to Kouri was after Eric was dead?
Her testimony was not that. She didn't remember it that way. We found digital evidence that suggested that.
So after Eric died, it is your understanding that there's still drug dealing going on between Kouri and Ms. Lauber?
I'm aware that Ms. Lauber conducted a similar transaction 2 months prior to Eric's death, after his death, with Ms. Richins.
On that, that's the occasion, I believe, and you were here. If I'm wrong, please correct me, but that's the occasion where Ms. Lauber claims that Kouri had to write her a check, right?
Yes.
And the check was written out on the Kouri Richins Realty checkbook, right? Because you recall from your investigation.
Yeah, I believe it was a K. Richins Realty check.
Did you do any corroboration or investigation into whether or not Carmen Lauber did actual work for Kouri Richins Realty that week?
Yeah, I mean, we talked to Carmen about her relationship with Kouri in all ways, and she said she had done some work for Kouri in several different capacities. As far as that week, I don't know that we ever got into those details.
That was the week that they were about to close on the Midway Mansion. Is that correct?
What date are you referring to?
The date that, oh, I'm sorry, strike that. That's fair. The week before she got the check is the week that the Midway Mansion closing allegedly happened, right? Right after Eric's death.
Your Honor, objection. The air quotes, this is testifying.
The air quotes were for the Midway Mansion. That's why I did that.
I understand.
That's what I call it. But for the house on Legacy, right? I won't do that again. The house on Legacy Drive.
Sorry, can you restate the whole question? I've forgotten it already.
The house on Legacy Drive had closed in between Eric's death and when Ms. Lauber allegedly got this check, correct?
Between Eric's death and when she got the check?
Right.
As far as my understanding, yes.
Did you ever talk to the realtor and say, hey, did Carmen Lauber clean up that house the week before it closed?
Which realtor?
The realtor for the Legacy house.
I'm not aware who that is.
You don't even know who was selling that house?
No.
So I guess the answer.
The sad part here is that the defense has a few points. In the middle of this white noise that is their cross-examination, they have a few points. Why can't they just do that? This would have been so much stronger cross-examination. Simple questions about things you know to make this guy look like a doofus. Now, folks, I've been doing my type of law for close to 35 years. I can see through the white noise and see, okay, this is what they are trying to do. That is what they are trying to do. But it all is fucking lost. Because they, with the exception of Mr. Ramos, they can't ask a simple question. It's infuriating. What they're trying to convey is this dude is incompetent. That's what they are trying to convey. But it gets lost because he doesn't know who closed on the house. Is that information he should have? Of course. It's in the central part of the investigation that she needed a lot of money. The house cost a lot of money. Who sold the house? That should be engraved in that guy's brain.
No, you never made any attempt to corroborate whether Carmen did work that week.
I don't know that the realtor would know the answer to that question, but I never talked to them.
Okay. And speaking of the Medway Mansion closing, we've had some testimony here about some closing documents that were signed and dated either the day after Eric died or a couple of days after Eric died. Did you hear that testimony?
I believe so, yeah.
Did you ever go to the people that conducted the closing and confirm whether Kouri was present at that closing in person?
No.
Are you aware that you can do closings on houses without being present in person?
I know nothing about realty.
Okay, well, then I'll let you have a pass on that. Did you ever do any determination as to whether those documents were signed through what's called DocuSign electronically?
I'm sorry, can you say the question again?
The closing documents for the legacy property, did you ever do any confirmation or investigation into whether those documents were signed via DocuSign or electronically without being with a wet signature and a pen?
The investigation into the signing on the house and the other financial documents, I wasn't a part of. That was through the prosecution's office's investigator and their experts, their forensic accountants. I wasn't really part of that.
As lead investigator, you can't testify that that was ever done here today.
I can't. I have no knowledge of it.
Okay. You did, you were involved in at least 8 of the 10 search warrants that were issued on this house? Because I think the first 2 were Detective
What do you
Wood.
mean by involved?
You were lead investigator once those warrants were being executed? I think the first 2 were Woody, so I don't want to credit those.
The
to you.
title of lead investigator doesn't necessarily mean what I did in those circumstances. I guess I would ask.
Okay, so we can conclude that this guy is a fucking moron. Sorry for you guys who feel attraction or likes his voice or anything. This guy is not a smart person. Were you involved in the other? Well, you're the lead investigator. You either were there or you got information of what happened there. That makes you fucking involved in it.
You to be a little more specific about what you're asking.
How many warrants are you aware were executed on the house, on the Richins home?
I believe around 10. I don't remember the exact number.
And in 10 different times of searching, was there ever any fentanyl recovered?
Throughout the 10 search warrants, anything that was recovered during those search warrants that we suspected may contain fentanyl, have traces of fentanyl, were sent to the state lab.
Okay.
We got results back from the state lab. There were some items that.
May we approach?
Okay.
Do you want
This is the moment that Defense Diaries talked about. He's he really tries to avoid answering the question. Because this is a very specific question, which makes me believe the defense has knowledge about this, but they need his or somebody else's acknowledgement. Now, they didn't go with the actual person who tested. They weren't allowed to ask about the specific items. So they are trying now through this person. Let's see. And that state was really, really fast. May we approach? So they definitely don't want whatever answer he had to be known.
Yeah.
Okay.
In any
Okay.
in the 10 search warrants that were executed on this house, did you ever find any cups, glasses, straws that contained any traces of fentanyl on them?
Let me be clear. I wasn't present at every single time that the house was searched. So the answer is investigators in my team or investigators from the Summit County Sheriff's Office did not find cups, straws, the things you mentioned that contain fentanyl, no.
As you sit here today, can you even tell this jury the exact time that Eric Richins died?
I don't know that anybody can.
Can you tell this jury how fentanyl got inside of Eric Richins? Based on evidence, not speculation or theory, but evidence.
I know it was orally ingested.
And that's all you know, right?
That's not all I know, but I know it was orally ingested.
That would have been a really, really great time to stop the cross-examination.
To this date, have you ever recovered any of the pills that Carmen Lauber allegedly gave to Kouri Richins to test to see what they are?
That I can confirm for sure are the pills that passed from Carmen's hand to Kouri's hand.
Correct.
No.
Okay.
Let's see the wording on that again.
To test to see what they are.
That I can confirm for sure are the pills that passed from Carmen's hand to Kouri's hand.
Correct.
That I can confirm are the ones that passed from between them two. Is there an inference that they did find something but they couldn't trace it? Or is it just him being bad at answering?
No.
Okay. Prior to Carmen Lauber's second, third, fourth interview, there was never a warrant issued for Kouri's arrest prior to that date. Is that correct?
I'm sorry, can you say the question again?
Prior to the interviews with Carmen Lauber, there was never, that was the first time you all requested an arrest. Well, let me say, because I won't say y'all. The first time there was ever a formal request to arrest Kouri Richins was after the interview with Carmen Lauber, correct?
After at least the first 3 interviews with Carmen Lauber, we had enough information that we believe met a probable cause standard for the arrest of Ms. Richins.
Okay.
We gave that information to the prosecutors, and they filed charges in this case. They then requested an arrest warrant be issued from 3rd District Court. I executed that warrant by arresting Ms. Richins.
Have you ever heard of hair follicle testing?
I think I've heard that term. I don't know what you're referring
What's your knowledge of it?
to. That people much smarter than me can test hair follicles for what it can tell you about the body's biology. About the
Specifically,
extent of what I know.
specifically, isn't it fair? You've been a narcotics officer for a long time.
Objection, Your Honor, relevant scope.
This is beyond the scope,
Your Honor, it goes to the investigation or lack thereof.
but beyond the scope of the version or the version of the direct examination regarding the investigation. You have other options to get into this. It's just not right now.
Okay. Court's indulgence for just a moment, Your Honor.
Of course.
When you searched Carmen's house, did you test any pills that were found in Carmen's house?
I don't remember. That would be a better question for Ms. Gibson. She handled all the evidence recovered from that search.
You were aware through your investigation that shortly before Eric's death, he was on a hunting trip in Mexico. Is that right?
Yes.
And the very last thing Eric ever did that we can establish before he passed away was a Google search, right?
I don't know if that's an accurate statement, but I know that a Google search was found on Eric's phone the night he died. That was, I think it was searching directions or how far it was from Utah to Sonora, Mexico, I think.
Right.
Like
And
if you had to drive, how long it would take to drive.
Okay. And did you do any investigation into where Eric went hunting when he was on his hunting trip in Mexico? Where was it?
Yeah, I don't remember the name of the outfitter. Todd Rice was the contact that we had with the hunting outfit in Mexico.
But I mean, where in Mexico? Was it
Oh.
the Sonora area?
I think so.
Also, according to Ms. Lauber, she estimated that each time she got pills that apparently she says she gave to Kouri, they were 15 to 30 pills per transaction. Is that accurate?
Her statements.
Your Honor, the foundation is to when? During interview, during testimony, during when?
To provide a little more foundation for the question, or a little more detail for the basis of the question.
What is your understanding of how many pills were involved in each transaction that ultimately allegedly went to Kouri?
Approximately, well, total or each time?
Each time.
Each time approximately 15 to 30.
Right. And that would be a total, again, math. But if you have 30 pills times 4, that's 120 pills.
That maths for me.
And you were in the courtroom when strike that. Did you give Carmen rides to meetings with her attorney in your car after she agreed to cooperate with you?
We helped transport Carmen when she couldn't get somewhere. It wasn't usually in my car. It was in Detective Maynard's, but yeah.
How often did you guys give Carmen rides places?
It was only a couple times.
Did you talk to her on the phone?
Yeah.
Check in with her? Went by and saw her at her house?
He'd answer Steve.
I'm sorry.
You got to say yes because they can't type.
Right.
Okay, so what was the answer to the last question about you called her on the phone?
Yes.
You would go by and see her in person?
Well, not just like to see her, but like if we needed to get in contact with her in person for some reason, yeah, sometimes we'd go to her house or her work, wherever she was at.
And this relationship or these interactions that you had with her extended from the time she agreed to cooperate with you to literally she showed up in court, right?
If you're referring to myself and Detective Maynard, yes, because Detective Maynard contacts and deals with Carmen a lot more than I do.
Okay. Getting close. I'm sorry. Thank you for your patience. Oh, okay. I want to talk about the Lord, if they're GIFs or GIFs, I don't know, but GIFs that have come in, those pictures of the goofy pictures that they said that Kouri accessed the morning of the 4th, right?
I'm sorry, who's they?
All right, I'll be more specific. The GIFs, you saw them come up on the screen. They were like joke GIFs, right? That it was testified to that Kouri's phone accessed them all at the same time the morning of March 4th, the morning Eric died, right?
What I understand about the gifts is that there were, I think, 3 different ones, and that they were somehow accessed on Kouri's device. The technical jargon of the digital forensics is whatever Mr. Cocherdimos testified to.
I'm with you on that. So clearly, I would imagine, as the lead investigator, if you're investigating a potential homicide, would it be important to you to look at the very last conversations that the decedent and the suspect had right before the death?
It could be part of it.
Did you do that?
I believe I did. I don't remember what the contents were, but
Katie, can you please pull up JO11? JO11? And this is only, okay. And make it a little bit bigger so that that Detective O'Driscoll can see it clearly. And take your time looking at this, and I'm going to ask you some questions about it. Do you recognize these texts? Keep going, quick, Katie.
I recognize that they are from Eric's device, yeah.
Okay. So Eric sent her those images or those GIFs. That wasn't what the prosecution said. That makes that part a whole different, because that, for the sake of argument, what the defense can claim is she found her husband dead. She just wanted to look at what they last talked about. And then, as a phone does, when you pull it up, look at the text messages, they access that text thread, including the images he sent her.
All right, and they're between whom?
Eric Richins and Kouri Richins.
And what is the date, sir? Can you blow them up,
Sorry, I'll have to
please?
zoom in.
Sorry.
March 3rd, 2022.
So this is the day, literally, his last day on Earth. And it's the conversation he had with his wife, right?
That's what it looks like.
All right.
I have
And,
to look at all the timestamps to
and
give
certainly,
accurate context for that. But
I'm really sorry, I didn't mean to interrupt you. Certainly you reviewed this as part of your investigation.
probably. I'm not remembering them, but
Your Honor, this,
I have not looked at every single text message on Eric's phone and on Kouri's phone.
sure, but like the day he died would be a kind of an important day to check out, right?
Yeah.
Okay, so do you
Like
recall?
I said, that's where we got the information about the hunting guide in Mexico. So yeah, we were looking at that information.
So then, Your Honor, may I please admit this as Defense Exhibit 300? I don't even know what we're on yet. 3010. Is it 10? It's 3015. We're a little behind. Thank you, Ms. Brittany. I appreciate that. We move to admit it.
Objection, foundation, or authenticity. I'm also looking at maybe approach.
Yeah.
Yeah.
Can we go to is this the first page, Katie?
Okay, well, he kind of authenticated it.
Let's pause there.
Okay, so the defense is trying to get in that these gifts were a part of the conversation between Kouri and Eric sent her those gifts. She didn't Google for them. She just checked the last thread they had together. And the state do not want that information known to the jury.
From both or more, or listen to any.
And I think
No, Your Honor.
Detective,
and I think that's it. All right. That actually puts us so we can start today. Finally. Let's see here. I'm just backing up here. Share. Boost. Sound.
begin.
Okay. A little bit earlier. And 1.25. But regard to the things yesterday. Yeah, the walk the dog letter. I still say with that, how she tries to get people to lie for her, that's my interpretation. That's the absolute worst she could have done. Because she really behaves like a guilty person. She is putting herself through her spoken words and her written words as the killer. And I still say that this officer, what a doofus.
We're on the record in 231-500-139, State of Utah
All right,
versus
finally, day 13.
Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present. May we begin by confirming whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday.
Yes. Yes, Your Honor, I think we do. May I stay seated so I can read my,
Of course.
okay, just 1 second, let me pull it up.
If we can all look at it at the same time, I'd appreciate it, Katie.
Are you pulling up the celebrate one or the, okay. So it's up on the screen right now. So it starts with Bates number state, STATE, 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Ms. Gibson.
Can you show me the Cellbrite
Yes,
version
sir.
of this?
We can, and we're pulling it up right now.
Why didn't you try to get this admitted when she was on the fucking stand then?
Yeah, forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right?
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them,
I
not all
don't
of them.
know if is that true. I thought
That's
all of them had the
No.
Cellbrite header.
That is not true.
Hold on, let's pause there for a second because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, I mean, we've had CDR related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted
Correct.
cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
But if
Screenshots, for example.
correct,
Yeah.
if it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th. So it's from the 3rd.
Okay. But these 3 bubbles are the sum total of their text traffic on the
No,
3rd?
we have more than 3. There's just a minute. There's a couple pages to it. It's the last set of texts that they there's multiple. See, that's the second page. And yeah. And that's the last text that they had between the two of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet? So as I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yeah, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Celebrite downloads that we have authenticated and laid foundation for, the time change is baked in.
Consistent across the board.
Consistent across the board.
Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrite download it came from. And I still don't know.
So that brings us to, is there a version of this that has the Cellbrite header?
that's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Oh, are you on a Mac? Oh, God. Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any, regarding foundation.
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we can work parallel while they're seeking out the foundation.
We're raided by Rosalind Duke. Yay! Thank you. Thank you, thank you, thank you. Thank you for the raid. Thank you for the raid. What did Rosalind Duke talk about today? I bet it was fun. What did you talk about today? Oh, Otter Creek. No. For the latest in the Owens were okay. So Laura Owens. Oh, Laura Owens. That's has something new happened in that case? I thought they didn't have anything new until, well, she did get herself a new lawyer, which means she probably won't take the plea deal. So I will try to catch that stream later. All right.
Information. We could address well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Well, it might be beyond the scope of direct, which is a stupid Utah rule that you have to cross-examine based on what the state wants. And then you have to call this fucking witness in your own case in chief to impeach them on something else. Or to get that's borderline burden shifting, in my opinion. But that's the Utah rule, so I'm guessing they have to get these. But these gifts are already in evidence. Go for rule of completeness.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd, and that was sent the day before. That is connected to the gifts, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of, and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury.
That's a weird fucking explanation. Lady, was the actual gifts in the text messages between Kouri and Eric?
All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective O'Driscoll? Why didn't you do it through Mr. Katradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant. I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing.
Yeah, but we're not talking about that picture. You were talking about getting the gifts in. And now all of a sudden we are talking about a picture he sent her the day before. Yeah, I watched the day before. This is a misrepresentation they did yesterday. What does GIF stand for? It's something, what is it? Graphic interchange format. Doesn't tell me much. From what they tried to elicit yesterday, they were talking about the GIFs. Now all of a sudden they're talking about the picture that he sent yesterday that were accessed at the same time, and is trying to make the inference that this was not purely, I'm not sure, but apparently those gifts were never sent to Kouri from Eric, the way the defense attorneys tried to inference yesterday. Again, I can't trust the defense. I can't trust the defense that their representations are correct, because here they sit outside the presence of the jury. Fuck's sake.
Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all.
Without the metadata, the picture is not relevant.
Well,
you need the date and time.
We have that. No. We do need the date and time, but I'm talking about the. I thought there was more information on the bottom of those things. And
why are we doing this through Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct, and we're not asking for that. That's all we're asking him, is to say that the picture was sent the 3rd. That's all I need him to say, and he knows that because he reviewed it, so he's capable.
He knows what he saw. How does he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so.
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that.
You would like to? No. If this is a technical question, it's not through the lead detective. What? This is so stupid. The judge is absolutely correct. This is not the witness to get this in with. That would be the person actually doing the technical bits. Oh, lady, what you want is absolutely fucking irrelevant.
You stupid woman!
This witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm not asking him for
I'm
any
not sure that's
technical.
even a dispute. Go ahead, Mr. Glover.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Glover.
I didn't have anything on.
Okay. Is there any objection to him just saying yes or no to that question?
If yes or no to the question of, did he review Eric Richins' text messages from the?
I think that's already been answered. Yes
Okay.
or no.
Yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
we've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
But
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see on. I still think there's a hearsay problem based on counsel's explanation. Now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo.
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense is, the defense is, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping photo.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died? Yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd? Yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh no, fair enough. I'm not telling you how to testify, and I don't know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand? Do we have a common understanding of the limits of what you can ask to take
Absolutely.
a O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to.
can't show the text messages without him provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
Because
that's
I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go
Are
ahead
you
and
going to publish the photo to the jury, though?
no?
Oh, okay.
So, we could just go ahead and admit 340 now, because then the next question is going to be: is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
So
it.
is somebody going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other. If we're resolved with this, I think we're all clear. I know what I can ask, what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
JK Debug, thank you for yet another. JK Debug says he likes to get me riled up. Well, he likes when I'm riled up. And then he made this. Thank you, JKD book.
All right. I really need Officer Driscoll to leave the courtroom when we talk about this because it's about specific questions.
No problem. Detective, if you'd take a step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
Okay. Thank you, Your Honor. I'm doing this out of an abundance of caution to avoid any potential. I'm trying to be very careful to comply with the court's ruling on the motion in limine not the motion in limine, the motion to admit the statements of David Norris. So
Not.
correct. Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval or actually we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but
Correct. The court did, the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
the residual.
I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry. I do have these if you want me to email them to you.
No, it's okay. Just give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl? Want me to read that again?
Sure.
And within the past few months, did your team of investigators become aware that there
Seriously, after the walk the dog letter, I don't trust anything that shows up out of the blue like that.
There was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl. And then there's one more question. Let me know when you're ready, Your Honor.
Sheriff investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blood.
No objection to the first question. Objections to the next three. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, or he was calling because defense counsel told him he should call.
Maybe we just pause here for a moment. I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there's no there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to properly investigate.
No, better number 2.
That is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
Yeah.
It would be reversible error for me to allow that question.
Yeah.
There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all of their possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed. And they were like, no, thank you. I think I'm entitled to get that in. And I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible. But I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something else.
No, Your Honors, I understand the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation of the charges. Yeah.
Your Honor, no, it's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the balance of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already admitted,
I think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right. Okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in. Correct? In all of putting it strongly, but yeah, that is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. Which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office or Sheriff's Office? My apologies.
Yeah.
He says yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
And if you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on. Fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth. It's being
100%
offered,
being offered.
Your Honor, if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case, by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Woody, the Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor,
Yes.
then the 807 residual exception wouldn't exist and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you have this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits
Right.
on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence for the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here, it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance is inadmissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
Wait just a moment.
Of course.
Yeah. I don't know why they want this. Well, of course, they want in that somebody told the law enforcement, hey, I know that Eric tried to get a hold of fentanyl. But the rule of evidence says, nah, that's not the correct way.
Okay, Your Honor, I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
I don't think this will be an appellate issue. Judge is deep in thought.
Let me take a minute.
No, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back. Thank you.
All right. Okay. Let's skip ahead.
Well, thank you for your patience. I've just handed you a copy of State versus McCullough, 2014
Okay.
UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state's state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Von Savage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement into question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office? Yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bonsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here too, because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris, or they call David Norris. And
Sure.
they ask, did you call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nik Bonsavage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this
Okay.
before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did,
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner is both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bonsavage, does that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law enforcement's investigation, not for the jury.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nik Savage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
Is when you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, well, I guess there's once as a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
that. Yeah.
proffer is, proffer is the,
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
none of the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need.
It's jury confusion.
Right. And
yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Hayden Jeffs and Nik Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And I don't know. I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so
You would be able to call an investigator, not a lawyer, right?
right.
Yeah.
So probably 3 witnesses.
Okay.
Um,
And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I appreciate that Hayden Jeff spoke directly to law enforcement in a recorded interview.
Right. That's what we would have to get into. What did you understand? Why? With what level of detail? Which is extraordinary.
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nik Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various prejudices, the prejudice with admitting Norton versus Norris, sorry, versus the prejudice of the Hayden Jeffs and Von Savage. I think the court needs to, in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion is not at all probative because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case. Whereas the Von Savage statement and the Hayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403 balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high stakes poker.
Yes, it is. I was just going to ask you if we could have a little time to meet with our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth, but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Von Savage, not for their truth, but to show what they were doing and how they were doing it.
Yeah.
Can I just get a clarification on the Von Savage? I want to make sure I'm on this.
Lady, if you are successful with this new case law that the judge found in admitting the statements, not as under the truth of the matter asserted, but as how did the cops react to it, you open the door for the prosecution to bring in witnesses who says she tried to get fentanyl because of the same reason. How did the investigators act on that information? That's a horrible idea for you, Mr. Defense. And Mo's back.
What in the bumblebee tuna is this outfit?
I think she is trying to get a job at UPS.
I was going to say either that or a very odd ABBA recreation band.
Boy Scouts of America?
Don't take cookies from her.
No.
Or popcorn.
Now, what has happened is that the defense wants statements from a person who claims Eric tried to get fentanyl, not for the truth of the matter, but as how did the investigation act upon that information.
Okay.
And the judge warned them if they succeed in this, then the court also have to allow similar statements, not for the truth of the matter asserted, but that the state has, and they have people saying, yeah, Kouri bought fentanyl.
Oh.
Yeah.
The defense has been odd because I guess I wanted to get your impression of the lead investigator. I contend that Kathy Nestor's cross of the lead investigator has been her first competent cross of this trial.
Yeah, but she gets points in a lot of white noise, but she does get the information from him eventually.
Yeah, and that's what I mean. She gets the this was not a great trial, but it's in with all her condescension, but it's
Mm.
been the most on target and
Mm.
not tangenty
Mm.
cross that she's had.
Yeah. And do you remember from yesterday about the gifts?
Yes,
Yeah,
yes.
yeah. And the defense said, well, the conversation between Kouri and Eric more or less contained these gifts.
Yeah.
Yeah. As it turns out, it didn't. They are trying to elicit that, well, she accessed these gifts at the same time as she accessed a photo from when Eric put gravel outside the mansion. Then he took a photo and sent it to her. And she accessed those roughly at the same time. Meaning it might have not been the way the state argues, but they are actually not in Eric's text with Kouri
Okay.
at all.
Yeah, that was the whole thing. I thought
Yeah.
that it wasn't Eric's text to Kouri. I thought that those were Kouri's text to Josh Grossman. That explained. Okay, I have been so off because I
Yeah.
thought the gifts were from that, not.
Yeah, but it seems like these are orphaned gifts. They don't really know where and when they appeared in her phone.
I hate everyone on this case. I hate the
Yeah.
state. I hate the defense. I hate everyone but the private investigator.
Yeah. I like the judge. I do.
Yeah, it's so irritating because it looks like the state was handed a really good, citizen or private investigator investigation, but they didn't really do anything with that, or at least no one can remember what they did.
Yeah. So that happened earlier, and now they are debating this. Now we are a bit behind, as per usual.
Oh, okay.
Yeah.
Have they done the Rule 17 motion or the or the deferred judgment? Or has the state rested yet, or are they still?
The state has not. They have been
Oh,
talking
okay.
all morning. They haven't concluded the cross-examination yet.
Oh,
I think
all right.
I think they have started that, but we are a bit behind. But they will now take a 10-minute break because they need to discuss with their client. Yeah, should we really have this Mr. Norris statement? Because if we do, the court will allow the state to talk about things people says you did, which is explicitly trying to buy fentanyl.
Oh, wow. Yeah.
So, yeah.
Same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bonsavage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nik Bonsavage says to the inmate something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
The word
substituted the word fentanyl for
illicit
street drugs.
Right. And that's a recording,
It is a recording.
as is Hayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for
I mean,
the Michael
we're
Jackson
talking
stuff,
about
and they
the
get into a
defense here.
Propofol discussion.
Right. Okay. How much time do you want, Ms. Nesser?
We have 30 minutes.
Fine.
Thank you, Your Honor.
Anything else before we take a recess, Mr. Glover?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30. All right.
And all of a sudden, we are catching up. A lot.
Ms. Richins, how does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still, he is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence,
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed
But they are
with
leaving
additional cross-examination of
They
Detective
might
O'Driscoll,
actually
correct?
Yes, sir.
do it.
Did we reach an end? Well, I'm
Well,
sorry.
Nick, can you
Could we
pause
just
it?
go ahead
Right.
and
Based on the way Kathy answered that question, I'm getting the distinct impression that Kouri really wants this in, and Kathy's
Yeah.
like, you know what? You put that on the record because I
Yeah.
have a. You can see because Kouri did that like
Yeah.
weird lizard thing she does with her mouth when she's pissed off.
Yeah. So Kouri not only tanks her own case, she makes the defense attorneys do really, really poor decisions.
Yeah, and let's be honest. As much as we've made fun of the defense, they have not had a good case. There
Yeah.
wasn't a unifying theory, and all their defendant gave them was basically spaghetti theories on the wall. Now, could they have handled this case so much better? Yes. But as far as, being a competent attorney, as much as it pains me to say, she's competent. And a lot of the things that I think she's pulling up and going with are things that Kouri's brought up.
Yeah. Yeah, it seems like it.
Except for the broke back defense. I honestly think that was a Nestor original.
Yeah. Yeah, that's still stupid.
Yeah.
well, I can just do it through. I think we decided I'd just ask him about 340. I'm sorry, and I apologize. I
Okay.
withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in, and then I will ask him if he can identify the photo. If he can't, he can't. But I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340, and then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date is a yes or no question?
Correct. Just
Okay.
on the date, not the time, because I don't want to confuse anyone or require the UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Zach, please. Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany. We'll get you sworn back in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Exactly.
And now the sidebar
Please
counter.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth,
No objections.
State's exhibit 3-40 is admitted.
All right. And this was talked about when I believe it was Mr. Kostradimos, I think it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
All right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay, can you pull up another one of the photos that is the picture from the house? That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the legacy mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think that requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I
Can we
think,
back up a step? Maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them.
Oh. Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone
Yes.
on the day before he died.
Yes.
I don't remember all of them. I remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes, Your
So,
Honor. Sorry, objection foundation is to the meaning of died, right? He was pronounced dead.
But I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection, his recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo and then I'm done.
I'll take you down, ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
say.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen and the witness is
My apologies. There you go.
staring at it.
Sorry.
Ooh.
Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
Oh.
Please tell me
This
his
cross-examination.
blind.
This cross-examination reminds me I need a dentist appointment.
Yeah, I'm over here just hoping that God's ugliest tie was like a gift from his blind mother. Like she thought it was the most beautiful thing. And so to respect his mother, he wears it, even though it doesn't go with anything.
He might be colorblind. He might think, but colorblind doesn't go for patterns.
Yeah.
And I can't think of any color with that pattern wouldn't be a violation of the Hague.
It was a choice.
One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Please let it be Bill
Okay,
Cosby.
so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time?
Yes.
And the one with the farmer is that exact same time?
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo was the same.
Perfect. Thank you. Okay. We can take that down now. All right. I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Cocherdemos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Yeah.
Sustained. Lay a little foundation there.
Are you aware that there was a search conducted on her house on April 13th?
On Ms. Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know that there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment.
Who the fuck in Kouri's family would make those searches on her
Yeah.
devices? Her kids? No, I highly doubt that.
No, and wouldn't that be, is Kouri trying to implicate her mom now?
Yeah, maybe. Jesus.
We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it. I'll tell you. Just one moment, I'm sorry, Your Honor. It's hard to keep all these exhibits straight.
That's kind of why they pay you money. That's kind of your entire
Can we
damn
put up
job.
exhibit 2-66R? It's admitted, Your Honor. Oh, wait, I'm sorry. Before we do that, can we put up exhibit, 2-66R? That's correct. We don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would you be so kind? I don't want to accidentally put something up that was redacted, Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it.
Oh. Kouri's mom had a partner that OD'd and Kouri's mom got an insurance payout from it? Oh, really?
2-66R, publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kid's school notebook, right?
Correct.
Okay, and can you fast forward, Katie, to until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that?
Mm-hmm.
You need to say yes.
Yes, sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as a, I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
No, no, maybe approaches.
I'll move on. I'm done with that. You
Are
don't know,
we
Sean?
approaching or moving on?
Why? We're moving on from the subject matter. No need to approach.
We are moving on from the subject matter.
Very good.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean,
Her stalker wall.
Yeah,
That was creepy.
I mean, at this point, I'm shocked that if the defense had access to this and knew that the state was going to try, I mean, maybe Carmen feels responsible because she's the only one responsible.
Yeah, I mean,
We have
that
more
would be an
evidence that
excellent
Carmen.
path. Yeah, that would be an excellent path for the defense. Have one theory to create reasonable doubt and stick with that one theory. Not all of them, because then it's just mashed up. The theory should have been all along, with this new information that we under the duration of the trial. Well, Carmen had an addiction. She wanted to make money. Fentanyl-laced pills was cheaper than oxys. She wanted to make more money. So while Kouri asked for oxys, she got fentanyl.
Yeah, I mean, that would have been a coherent, again, it's just as nebulous. It's going to be hard to prove, but that's the thing. The state can't prove their thing either. And it's much more likely to think that, hey, Carmen, she wanted to shift, she wanted to scam a rich girl. A rich girl doesn't know what's going on.
Yeah. But
that's extremely plausible.
But that's the problem with the defense is they have so many. He's gay. He did it to himself, which has been a large part of this. Well, he must have done it for himself. Now, if they have gone with that theory, every person that knew him, they would ask about things that they didn't know about him. Oh, so he hid it from you.
Yeah, and
But
you
they
have
never
to have
did.
You have to pick a theme and stick with it. You can't ask several people, "Oh, was he having an emotional affair?" And then other people, "Oh, he was hiding, drugs in Kouri's luggage."
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think.
Hold on. What's going on in chat? What? Are you having hail? Storm and hail is really bad because that is really strong winds and really cool air that creates hail, which you see around tornadoes. So if you're having strong winds and hail, get to fucking safety.
Yes.
Um,
Watch out, Ryan Hall. We're coming for you.
yeah. You would like to see Ryan Hall through the monitor, not because you're passing by him by just the wind. Oh, no tornadoes, only Mother Nature on crack. Okay.
Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that one's got things
Would you
blurred.
help us out? Thank you. Let's see. This is 8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Katie does have this one. You wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we switch it back to her, please? I'm so sorry. There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right. Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing text between Eric and Kouri, Katie, if you could pull up exhibit 2- I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
Right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing that you're asking about.
Okay. I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination. Okay.
Okay.
Can you blow that up? It's exhibit 2-3D as in Delta. And just let him look at all of them, please. Just slowly. Give him plenty of time to read.
I don't see how this moves any needle anywhere.
I think she was doing better yesterday. This is just turned
Can you
into
back up? I
white
think one
noise.
of
She's
them-
not making any
That one.
impact.
There you go. The next page.
I mean, she had an excellent stopping point
Does
yesterday.
this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh,
I
sorry.
mean, imagine yesterday. First of all, she asked way too long questions, way too vague questions. And then she had this moment of clarity. You don't know when he died, right? No. You don't know how he got it in him. Well, he ingested it. Yeah, but through what? And that's kind of a huge part of the case, because you're charging her with knowingly and deliberately doing this to him.
Yeah, that's why I'm so very much torn, because I think with everything we've seen, it's very, very likely, like 95% likely that she did it. But that's not 100%, and that's not beyond a reasonable doubt. But I think she's going to be found guilty.
Yeah.
Now,
simply because of her own actions and words and texts.
Nick,
and
when it comes to when eventually the defense makes their motions for judgments, I do think that they have a very good chance with the attempted murder on Valentine's Day.
Yeah,
For me, that's the one that the state has never proven to me and can afford to lose.
Yeah, I don't. There's no buy of drugs in the immediately on, before, or after. I mean, 2 days before to 2 days after. There's no purchase recipe or anything. And there's no reports anywhere. So what have the prosecution, because motion for vacated for getting it out of here, that everything must be in the best possible light for the prosecution. What have they actually put forward as evidence? He became sick.
Yeah,
and he talked about it, and then they laughed about it afterwards. Oh, ha, 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 she tried to poison me.
Yeah, so I think that one of all of the things, I think the state, if the defense makes that point, I think the state should roll with it, because that's the one that I think of all of them is their weakest of their case.
Yeah, but they still need it as a
As
continuation, as pattern. So, yeah.
Sorry, keep letting him read it.
There's really no percentage when it comes to beyond reasonable doubt.
This series of texts between Kouri and Eric relating to the trust.
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor.
Yeah, folks. Generally, my bar of beyond reasonable doubt is it's higher than most others, much higher. And it's, as I say, I'm very pro-defense. After the state's opening statements, I have a lot of questions. They have to answer each and every one of them until I only have unreasonable questions left. Then I am at beyond reasonable doubt. I know most others have a different standard.
Yeah, and I think my standard has changed since I started watching trials. I believe, if I had just started watching the Kouri Richins trial at the start of my journey, I would say, like, she is all the guilty. Like, no one. But after many years of watching, I see what the state hasn't done.
And I have no idea what the defense can put on to make things better. They have to explain grief. Yes, she made a lot of stupid decisions. That's grief. They have to have somebody to explain the fentanyl in some way, shape. How was the market in March 2022 was fentanyl sold as oxys.
Yeah. And it also they also need someone to explain that grief, often tears families apart. They need to explain that this is not unusual when large amounts of money are, in play, that families break up. And if things are found, if the marriages are found to be not, the greatest, that, sides can form. You need to find a reasonable explanation for all the things that looked terrible. Like you can, and she shot herself in the foot. Had she done what Nick Rekieta said and, told Josh, hey, I need to lay low, didn't fight with Katie, said, look, I don't care. I understand I've done some crappy stuff. Let's just make sure the boys are okay.
Yeah.
Had she done all of that, I don't think it would have gotten this far.
Yeah. And thank you, Granny Smith. Member for one day says, only a month. Coffee is on me today. And she bought me 5 cups of coffee. 5. Thank you so much.
Awesome
That is
sauce.
so generous. So generous. Yes, folks. If you want to support my channel with money, you can do that with super chats, gifted memberships. If you don't, then of course YouTube takes their cut. If you want more money of your money to come to me, you choose Buy Me a Coffee or PayPal, which only has somewhere between a 3 and 5% cut, while YouTube is 30%. Now, YouTube also provides this for free.
Yeah.
So, but then again, I have monetization on, and yeah. And for Replay Crew, there will be ads, so they will make their money anyways. And of course, always appreciated, never necessary. I'm not asking anything. If you're choosing between bread and me, bread. If you go to Starbucks 3 times a day, hand me one of them. That's the level. If you're a millionaire, call me. Let's make arrangements.
Why is it Kouri's the only one that found a rich man in college?
Yeah. Oh. Now, if you want to wait until Saturday when me and Mo are doing the Laura Owens, we are going to start to, for people who just got interested in the Laura Owens story, the serial pregnancy scammer out of Arizona. But, this is a lot of information to go through. Me and Mo will take you back to the beginning, and every Saturday for a few hours, while having a drink of choice, we will go through it with you.
Yes. And what in the crazy... I truly do think Kouri Richins is Laura Owens with a little bit of discipline.
Yeah. Because Laura Owens is one of the strangest, but she's not unique. That's the really, really disgusting part. Now, she pretends to be, once a man says, no, I don't want you, she says she's pregnant, and she manufactures evidence to prove that she's pregnant. She puts out restraining orders, claiming abuse. She, for over a decade, she's done this with 5 men. 4 we have the names of. There is a 5th. She has done this for the past 10 years and probably more. And finally, the state of Arizona has 14 felony charges. Yeah.
She's
And she
not gonna happen.
yeah. And yeah. So that is going to happen every Saturday with a drink of choice or gummies. I don't care. Just make sure there are actually THC gummies, not
Yes.
the worst kinds.
Yeah.
And let's just have fun with it.
Yeah.
Yeah. And tomorrow, now it is tomorrow. Yesterday
Yes.
it wasn't tomorrow. Yeah. Tomorrow on our panel show, because apparently this trial won't be over, which we thought last year. You remember that was such a good time when we thought
Yep.
this trial would be over this week.
Yeah, I remember it because the judges are way too optimistic. They're always
Yeah.
like, we are moving right along. They are like the most optimistic lying to you tour guides ever. Like,
Yeah.
you just need to wait a couple minutes.
Yeah, not going to happen. It's like renovating a house. It takes twice as long and costs double the amount.
Oh, did you read the amount that Kouri thought would rehabilitate the house? She made Eric do all the estimates, and it was like
No.
$2 million for a swimming pool, like golf court, just all the crazy. She's insane.
Yeah. But tomorrow at our panel show, which will begin directly after the trial stops, we will have a lawyer explains as a guest to go through this case. And so that will be amazing.
Yes, I have loved all of his takes because he really is. I know me. I know I can be a bit judgmental, but he kind of takes it back, and I'm like, okay, he does all right. You know, he pointed out something good, and
Yeah. And did you, because he reviewed the private investigator cross-examination, and he called it
wrestling. Don't wrestle with it.
Don't mud wrestle with a pig. You both
Yeah.
will lose, and the pig enjoys it.
Yeah, and I think he's really good at pointing out on both sides where lawyers might do a better job, and
Yeah.
he's been spot on with his observations about the case.
Yeah. So I can't wait to have him on here so you guys can ask him questions. I can ask him questions. He can ask us questions. Yeah, it will be amazing. But that's for
Yes.
tomorrow. Let's go with... I can see dead people with a beard here. Am I the only one who thinks...
Oh God,
that's
he
the-
does look like Haley Joel Osment. But Haley Joel Osment is really fluffy, so
Yeah.
he does look like a skinny Haley Joel Osment.
Yeah.
Oh my gosh, we need to put that on the thumb tag tomorrow. Like I see crimes, but not patterns, and we just point to his tie.
I see fentanyl.
That's not the thing.
Sidebar.
Looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's basically hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it, there may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor, foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor. Is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right. I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
Hey!
It would be relevant because they didn't.
Sidebar counter 86! One step closer to 100, where we both say, yeah, we'll take a shot.
Yep.
Find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you.
So where the fuck did the fentanyl come from?
You also testified, I think, yesterday that
And hydrocodones
shortly before
aren't
Eric passed away,
Roxy's.
he went on a hunting trip to Mexico. We talked about that a little bit, right?
Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Cotradimos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up.
Oh, really?
Like mid-thought?
All right, we're almost done. So just to recap a couple of
Dolly Raid. Hey,
And welcome.
welcome, Dolly Raiders. And we are about to. Well, the defense cross here is about to wrap up. They had 2 or 3 good points yesterday in an hour and a half, covered in white noise. And today they had white noise.
Sadly, though, this has been the most effective examination Miss Nestor's had.
Yeah, they got a bunch of evidence in through him, which I strongly believe is absolutely worthless. But they got him in, which is more than we can say about what happened the other 2.5 weeks.
days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
They have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
No, a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay.
What?
Well, I mean,
Technically, you don't know the dosage, but
Well-
it shows pills or powder.
yeah,
Well,
but
that-
I mean, I guess there's not a recommended dose of crack or heroin or, you know.
Yeah, but
How-
we discussed this earlier, that we don't know how much of what they are presenting is because of Kouri.
Yeah, Kouri seems hell-bent to get some of this information in, whether it will help
Yeah.
her or hurt her.
Yeah, but she only sees, oh, look at how much money I can make of flipping houses. And then she only sees, ignore the loans. They paid me! Yay! Celebration! Drugs! New boyfriend! Same movement.
Yeah. She should have just, modeled for a shake weight. And she's not unattractive. She should have just had an OnlyFans. I mean,
Mm.
look, the entire town already thinks you're a harlot. You have, a nice body. Just show bikini pictures.
Yeah, I mean, she honestly believed she was worth $11 million. And I'm here after looking, and I don't do math, and I'm saying, no, you are $7.5 million in debt, and you hope to sell things for a combined $11 million.
It's kind of
And then everything foreclosed.
It's kind of like when you look at yourself on Social Blade and you're like, gosh, I wish I were making as much as it assumes I'm making.
Yeah.
Yeah.
You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl was definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance
no.
fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company, have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach Valentine?
And here we go.
Mr. Bloodworth, you are pushing us to drink.
I think he knows. Sidebar counter 87! I think he knows.
Probably.
Restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
Was it?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection. Well, not objection. Maybe approach.
Sure.
Thank you.
She is preparing for the directed verdict. So she can use his words included in the directed verdict. And sidebar counter 88.
Fine.
Oh.
Okay, I'll withdraw that question, Your Honor. And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
not Eric.
Probably not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
You barely knew any details of this investigation.
Yeah, it's, and to be very fair to him, yes, it has been a long trial, but as far as fact pattern or even evidence pattern, this is a fairly not complex. This is not a complex case.
No. There's a lot of information in it because Kouri can't shut the fuck up.
Yeah, but as
But
far
the
as
actual evidence is really, really limited. You have he died between 9 p.m. and 3 a.m. He by fentanyl. You have now you have phone records, text messages, you have the letters and stuff. But from an evidentiary, when it comes to direct evidence, physical evidence, it's not a lot. It should be really easy for a seasoned investigator to at least go through it.
yeah, that's what you notice other lead investigators writing notes. He was just sitting there this whole time. I don't know
Yeah.
if this seems like his first case,
Hmm.
and hopefully someone on the DA side has pulled him aside and say, "Hey, dingus, take notes. Don't look this stupid ever again."
Yeah.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Kochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which day did you say?
Early 2023.
They had a little. I mean, how early? Not till March and April.
Well, let me ask you
January, 0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Kochodimos and Ms. Carrington?
Yes.
And is Mr. Kochodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
We
did,
didn't even get into that until well after.
and did it predate any of Mr. Cotodemos's investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Need my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with prosecutors or talk with her attorney here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators see someone's cell phone without a warrant based upon probable cause?
No, it has to be consent or a warrant.
Yeah,
At any
consent
time, have
or a
you
warrant.
believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
I'm sorry, is he finished? We have no further questions. Thank you.
May we release this witness?
Yes, Your Honor.
Mr. Blebber.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Blebber.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. It's up the state good. I think we marked it as 865. We'll admit that now.
Okay. Can I see it for a moment? Fact, preamble, and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now, during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. State's Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Blebber,
Your Honor, state's in an interesting posture.
do you need a moment on the record outside the presence of the
We
jury?
do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now, but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you steak dinner it's going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bail.
All right, the jury. A lot of steaks.
We have lunch coming, right? Okay, very good. That's it. I just appreciate it.
Yeah.
Have a seat, folks. Thank you.
And you're up.
All right, Mr. Bloodworth, we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter. Because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case in chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bonsavich's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
Thank you.
Oh, thank you. Thank you.
Thank you.
Oh,
Thank you. Oh. What? Oh.
this
I'm
is
so
a
happy.
miracle. Yes, because he is actually going to make points and I think have the most coherent argument.
Yeah. All right. Wow, we are only 33 minutes behind. That gotta be a
Wow.
record.
That is good.
Yeah, RJ, they are letting him speak.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or an account thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is a position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here.
Wait a minute. But she signed it on a life insurance, which means you intended to get money in an eventuality. So it was an attempt to defraud, just not immediately.
Yeah.
In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage, count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl. That Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxy. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again, according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or the
P.O. box circumstantial evidence that Eric didn't know about it.
Not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. If I bring that up, I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, that I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl. One, even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Before we continue, there's a retired judge, Carol Erskine, on X, who has something interesting to say here. Let me put this up. There it is. Who says, I can't remember ever seeing a trial with more appellate issues than this one. Defense lawyers at times are weak on evidence, procedure, statutes, and rules, and often have to be instructed on the law. Prosecution gets unjustified latitude with asking leading questions on direct, with a prime example of wholly objectionable testimony on day 12. It seems like an alternative world of trial jurisprudence when a judge with a standalone duty to ensure a fair trial and protect the Sixth Amendment rights of a defendant allows the lead investigator, who has sat in on the room and heard every word of every witness, including Carmen, sit on the stand and grade the defense's performance, with the detective agreeing it was misleading. That's for the jury to decide. There are, in my view, hundreds of mistakes in this case, leaving very real issues for appeal if there is a conviction.
I have wondered about how just absolutely odd a lot of the things have been in this case. And I didn't know if maybe it was Utah had different rules or different.
Yeah, and Utah has some, and let's see here. I don't remember what. Let's see here, where she used to practice law in Massachusetts. So it's not Utah. So yeah, this is, and from Ian and Defense Diaries, who are both stunned how the book was admitted as evidence. And I kind of agree, because that book, what's the probative value?
I mean, other than, again, the state has given us like 95 and then 900 million examples of Kouri being a shit person.
Yeah. But often her shit decision has to do with the economics and everything. This is her book on how to explain grief for children.
The only thing I can think that the state put it in was to again show that she is not honest and
yeah, so it will be interesting, because I assumed there was, but this is kind of a wake-up call, because Carol Erskine is a highly regarded former judge.
I think that this trial,
and I can tell you this, she doesn't give two shits on a straw about anyone's opinion on YouTube.
oh, I doubt it. She cares deeply about my opinion, but everyone else, she's like, meh.
Yeah. John says her mother sent the book anonymously to try to influence the investigation. Yeah, but that necessarily doesn't make it into an evidence, because Kouri didn't send it. Her mother did. So why is Johnny Depp trending? I have no idea. Well, they might be trending on my. Let's check. Oh, look, a squirrel. Let's go with latest. I have no clue. Shane McGowan tribute album.
I don't know who Shane McGowan is.
He is, or was, the...
Oh, the little boy?
No, Shane McGowan was the lead singer in a punk band. He did the punk band. He without teeth guy who sang the Christmas song.
Oh, okay.
Yeah. So apparently, but he passed away years ago. The Streets of New York, or whatever the song is called. Yeah, it's a very popular Christmas song. Yeah, I don't know why he's trending. He should be. He's a great actor. So yeah. I don't know. I mean, it gives a bit of a wake-up call when Carol says this. And I kind of agree with, because the state has been allowed to lead the witnesses. But the defense haven't objected.
Yeah, that's the other thing.
Yeah. So it's an own goal from the defense in that regard.
Well, John Gary,
this trial.
John Gary brought up a good point that part of the book talk was the big one she was going to write.
Yeah, but have we actually seen anything about the big one? She only talked about getting them bitches.
Well, yeah. I mean, possibly. Oh.
The Depp is in the e-files? Okay. I'm quite sure. I don't know if they tried to get him there and they didn't want to. Yeah, ineffective counsel. But yeah, but the bar is so high. And there's 3 of them. So yeah, I just thought I would show it to give just a rattle our chains a bit, especially when it comes from Carol Erskine. Yeah, interesting. But we are here for this.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Malber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence, in the light most favorable to the state, that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, Mr. Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2, the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood.
Thank you.
Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. Appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right. Okay, let's see his decision. I suspect no directed verdict.
No, given
Counsel for the state are present. Counsel for defendant.
the shortness of the time he's deliberating, because I will say that he will go back and look at things when he's unsure, but he seems to be pretty sure in his legal thinking.
And the defendant are present. The issue before the court is defendant's motion for a directed verdict, seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court and State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied.
Yeah.
Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m. Just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
Interesting.
Okay, and yeah, they are on break.
I mean, I think that the defense threw everything they had, and unfortunately the statute says the slightest bit of evidence, and
Yeah. But even with this absolute best intentions towards the state, I don't see the attempted murder on the 14th. In my opinion, there's literal zero evidence.
that's kind of how I thought, and that's what I would have thought had the judge thought critically. I mean, and again, maybe that's the one that I think that they should have, instead of trying to go for all of the charges,
Just go
he
for
should
that
have,
one.
hammered that one.
Yeah.
Because
So,
while I think he has a point for each of the charges, that there are things that were missed, if you're not likely to get all of them, go for the one that has the least evidence.
yeah. Okay, folks. Now, Mo here has
Yes.
her scheduled for 1:30. Or
3:30 my time. So it's 2:30 now. So in about an hour.
An hour.
But that way we can speed through
Yeah.
breaks and stuff, and stay on track, because we want to get to that panel show tomorrow. So there's no off
Yeah.
we fuck, and we'll just speed run it in the morning.
Exactly. Exactly. And well, we still have the possibility that the defense will not put up a case in chief. I highly doubt it.
Yeah. Now, it'll be interesting to see if they bring a lot of character witnesses, if they bring the mom.
Oh,
They
if
need
they
to
bring
bring-
the mom, that would be a mistake.
Yeah, I think we'll see how much Kouri's actually running this, depending on how the outcome of this 30-minute, like, I swear to God, we're not do you want to, like,
Yeah. Please don't incriminate us.
yeah, like, look, you can bring whatever you want in, but I'm gonna need you to sign this in front of Judge Hot Voice.
Yeah. A mistake, so they will do it. Yeah. Oh. This trial should have been over by now.
Oh God, yes, it should have.
but it isn't. And then we don't know if they put up a case in chief, we don't know what the state will put up as a rebuttal. With how they have acted, the defense, throughout the trial, they will probably put her on the stand so she can explain herself.
Well, that
will be entertaining.
I do think Kouri is going to push. I think Kouri, for all her life, with Eric, with everyone, has been able to explain things away. And she's going to be the client because she is just smart enough to know it's her right to get up there and do it, and just dumb enough to think she can change people's minds.
Yeah. Yeah, this will be Murdoch on the stand, making things worse.
This will be Tony Todd on the stand.
Yeah. Yeah, this would be Jeffrey Dahmer on the stand. I mean...
Well, not only that, but she will want to... Not only will she come off as incredibly terrible, but she will want to respond Sarah Boone style to every single perceived slight she felt.
Please, yeah. Please, no snotty crying. I'm not saying anything. I have no idea. I think she will start off as very timid, and then she can't help herself.
Yeah.
Yeah, it's like Jeffrey Dahmer on an episode of Hell's Kitchen. Yeah.
And Panzerdu, you are correct. Yes, this is to establish a record that they did, say, hey, because if they didn't raise these issues now, then they cannot raise them on appeal. So it is part of the protection of the record. You are correct. I will say, I thought that they had a better chance than most typical cases with the scant evidence.
The lawyers... Okay, Kurt called RA and said the lawyers get to decide whether or not call the other witnesses. Obviously, whether Kouri testifies is up to her. Yeah, but she does have influence over her case, in her defense case. If she tells them call all the people, they call all the people.
Yeah, and I think that this is I think I agree with Panzerdu. I think this is kind of like a self-defense case in that you need to testify that it's reasonable. Hey, yeah, I know you guys saw the steps. We have a dog. I didn't want it peeing on the carpet. I don't think about those things. Those are just things I do every morning. I was thinking about cuddling with my husband.
Yeah. And as Panzer also says, she's the only one who can explain the walk the dog letter.
Fair point.
Yeah. And with that, I need more than candy in my stomach.
Probably.
Yeah. You had good food on your break.
Yes.
What did you have?
Brisket sandwich and green beans with bacon and potato salad. But Mr. Mo ate the green beans and the potato salad because I'm not a big fan, but I ate the brisket.
If it's green or have the word salad in it, you're not... No.
Well, so they had the salt kind of up there, and I don't typically like a lot of salt, but I forgot that since we were... Bless our hearts, we were maybe the youngest people there, so they didn't add extra salt. So
Oh. All right, folks. Thank you. And from me, Mo, Mr. Jingles, who's now inside a box he shouldn't be inside of, but at least he doesn't scratch up me. We'll see you again in 50 minutes.
Yeah.
And you will be redirected over there. And if you're not, go subscribe. Okay?
Yeah. Bye, you guys.
See ya. Bye-bye.
See ya.
Snowstorm on the TV glow.